Hello. This session today that I'm going to discuss is going to be about the courts. And let's be honest, the courts of the various branches of government and things in life is probably the most difficult thing for most people to understand and comprehend. And the reason for that is our knowledge of the judicial system is through watching Divorce Court, Judge Joe Brown, a variety of other TV shows that give you afternoon justice. And when we think about the courts, and kind of the reason I wore this shirt intentionally today, because it relates to Johns Hopkins in this respect. We think of courts, we think of people suing somebody. People suing a hospital because they don't like something that's happened to them, a surgery that quote-unquote went wrong, or something that happened, a medical mistake, whatever. We are a litigious society. We look at everything thinking something went wrong, let's sue, let's get legal action, let's get some M-O-N-E-Y. Article 3 of the Constitution discusses the power of the judicial branch. And if you look at Article 3 and read it, it's not very long at all. The federal court system is established with Congress having the power to create other courts. We have a Supreme Court. The Constitution doesn't say how many judges. Originally, the Supreme Court only had about 6 or 7 justices. It wasn't until the late 1800s where the number was firmly established at the number 9. And that's why we have 9 justices on the court. There's no age or residency requirements. Those are up to Congress to make any requirements for that. Our legal system is a system of settling disputes. And I'm going to throw a few terms out there not to complicate anything too much. There's common law, which a simple definition is judge-made law. Laws made by judges. Legal precedents. Settling disputes between having judges make the final decision in this thing. Precedent is a strong aspect of the American judicial system. Part of precedent is let's not change things all the time. Let's keep the tradition of law in place. You don't want to have one thing declared legal one year, and the next year it's illegal, then it's back to being legal, and then it's illegal again. You want strong precedent in law, and that is very important in any society. You have terms like a writ of certiorari, an order issued by a higher court to a lower court, asking for the records of a case to be sent up for review. This happens in a situation regarding appeals. Two of the most common elements of law that we hear about is criminal law and civil law. I'm going to give you a simple explanation. Criminal law is where you could end up in jail. The prosecutor is trying to send your butt to jail for something you did. Civil law, it's about suing somebody. Something happens, you're angry, you sue. You don't like a result, you sue. Civil law, you're seeking financial compensation, like those TV shows you watch in the afternoon regarding all those half-hour cases where all the problems get resolved. The most important Supreme Court case ever in American history was Marbury versus Madison. And in the Marbury versus Madison case, the key thing to remember is it established the principle of judicial review. The rights of the courts to review laws, to declare them legal or illegal, constitutional or unconstitutional. I'll have some videos later on that you'll be able to see and go into on YouTube and other places that gives the history of Marbury versus Madison. There are 2 aspects we often hear about our courts. Judicial activism, judicial restraint. Judicial activism is a concept in law that basically courts will actively create and expand new rights. The concept of judicial restraint is more conservative, a concept that basically believes the court should not establish and create new policies and laws. That's for the legislative branch to decide. A couple of little aspects I'll throw at you regarding the courts and the legal system. We often think of the Attorney General as a powerful person, but one of the most powerful persons in our legal system is someone you may not even know who they are, or not even know this title, the United States Solicitor General. They are the chief lawyer for the United States that argues cases before the Supreme Court. They are the lawyer that takes the position of the government. I'll give you an example of this. During the Obama administration, the chief lawyer for the United States government decided to not enforce an aspect of the law in court. The chief lawyer for the United States government felt that the policy of the Defense of Marriage Act should not be defended by the United States. So they took the legal position of opposing a U.S. law. And of course, in 2015, the Supreme Court said that marriage between same-sex couples was okay. Solicitor General, they determine what the legal position of the U.S. government is going to be. There are over 10,000 cases that get appealed to the United States Supreme Court every single year. And out of those 10,000 cases, the Supreme Court only hears oral arguments in about 150 of those cases. So it has to be something really special or some sort of legal matter that's considered critical for the Supreme Court to actually hear oral arguments. What happens is your case gets to the Supreme Court. Each side lawyer gets 1 hour to present their case to the judges. Any time during oral arguments, the justices can interrupt the lawyer, ask them a variety of questions, and make legal points and arguments, and ask the attorney to defend those points and say why they should rule the way they want them to rule. Afterwards, what happens next is the justices later on go into conference. They discuss the case, they take a preliminary vote, and based on that vote, it is decided who writes the majority opinion of the court. If it's a 5-4 case and the Chief Justice of the Supreme Court's on the winning side, he picks who writes the case. The justice with the most seniority on the losing side picks who writes the opinion for the losers. If the Chief Justice is in the minority, the justice with the most seniority on the winning side picks who writes the opinion. And the justice with the most seniority, or if it's the Chief Justice on the losing side, picks who writes the opinion of the court. This is some of the aspects of how things go with the courts. One of the things that happens in Supreme Court cases is a concept of animus curiae briefs, a Latin term for friend of the court. What happens is various people will write briefs to the Supreme Courts. Think of them as persuasion arguments using legalities, saying here's why you should rule this way, United States Supreme Court. And that's how that part of the system goes. One last thing I want to talk about in this discussion is the nomination of judges to the federal bench. Presidents will generally pick justices who have similar ideology and beliefs that they have. Liberal presidents are going to appoint liberal judges. Conservative presidents are going to appoint conservative judges. That's how the system goes. And generally, for the most part, when someone is nominated to a judgeship, the chance of them getting confirmed is very, very high. It is a very political situation because there's so many cases that will later come up before the court. A lot of times, groups and parties will often determine their support or opposition to a candidate based on maybe 1 or 2 issues, usually that issue being abortion. And especially when you have a situation of someone being appointed or nominated, I should say, to the United States Supreme Court, where that becomes the focus of the whole debate whether the person should be confirmed or not. Next time I do one of these lecture talks, it's going to feature a discussion of constitutional rights in Supreme Court cases. Most importantly of all, take care. Have a great day.